Welcome to The Docket. I'm your host, Corey Snow. This is episode 35. At midnight on January 13th, 2025, after extensive litigation by Donald Trump in an attempt to prevent it, the U.S. Department of Justice released Volume 1 of the report by Special Counsel Jack Smith, which describes the Special Counsel's work to investigate and prosecute Donald Trump for his attempts to overturn the 2020 presidential election. The report comprises 6 sections and an appendix. This episode is an audio reading of Part 2, The Law. This section details exactly what laws Trump is alleged to have violated and their history, as well as how the Special Counsel's office planned to address any potential defenses Trump might raise at trial. For the sake of clarity, footnotes are omitted and most legal citations are omitted or simplified. The original document is available at a link in the show notes. Part 2. The Law. Based on the above facts, and after analyzing the relevant criminal statutes, the office sought and a grand jury found probable cause for an indictment of Mr. Trump on 4 federal charges: conspiring to obstruct the governmental function of selecting and certifying the President of the United States in violation of 18 U.S.C. Section 371, obstructing and attempting to obstruct the official proceeding on January 6, 2021, in violation of 18 U.S.C. Section 1512, conspiring to obstruct the official proceeding in violation of 18 U.S.C. Section 1512, and conspiring to violate the federal rights of citizens to vote and have their votes counted in violation of 18 U.S.C. Section 241. Because of the unprecedented facts and the variety of legal issues that would be litigated in this case, the office was aware that the case would involve litigation risks, as would any case of this scope and complexity. However, after an exhaustive and detailed review of the law, the office concluded that the charges were well supported and would survive any legal challenges absent a change in the law as it existed at the time of indictment. As set forth in Section 5D below, after the original indictment was returned, the Supreme Court ruled in Trump v. United States that Mr. Trump had absolute immunity for core presidential conduct, enjoyed a rebuttable presumption of immunity for other official presidential acts, and had no immunity for unofficial conduct. The Supreme Court's decision required the office to reanalyze the evidence it had collected. The original indictment alleged that Mr. Trump, as the incumbent president, used all available tools and powers, both private and official, to overturn the legitimate results of the election, despite notice, including from official advisors, that his fraud claims were false and he had lost the election. Given the Supreme Court's ruling, the office re-evaluated the evidence and assessed whether Mr. Trump's non-immune conduct, either his private conduct as a candidate or official conduct for which the office could rebut the presumption of immunity, violated federal law. The office concluded that it did. After doing so, the office sought and a new grand jury issued a superseding indictment with identical charges but based only on conduct that was not immune because it was either unofficial or any presumptive immunity could be rebutted. This section reviews the federal laws violated by Mr. Trump's non-immunized conduct. A. Conspiracy to defraud the United States. 18 U.S.C. Section 371. The defraud clause of the General Conspiracy Statute makes it a crime, quote, if 2 or more persons conspire to defraud the United States or any agency thereof in any manner or for any purpose, and 1 or more of such persons do any act to effect the object of the conspiracy, end quote. The defraud clause applies not just to schemes to cheat the government out of money or property, but also to schemes, quote, to interfere with or obstruct one of its lawful governmental functions by deceit, craft, or trickery, or at least by means that are dishonest, end quote. Hammerschmidt v. United States, 1924. Under long-standing, established precedent, the government must prove the following elements to establish a violation of the defraud clause. 1. The defendant, quote, entered into an agreement. 2. To obstruct a lawful function of the government or an agency of the government. 3. By deceitful or dishonest means. And 4. At least one overt act was taken in furtherance of that conspiracy. End quote. United States v. Concord Management and Consulting, LLC, 2018. The office concluded that Mr. Trump's conduct satisfied each of these established elements of a defraud clause offense. The process of selecting and certifying the president, as described above and prescribed by the Constitution and federal law, is plainly a lawful function of the federal government. Cf. Ray v. Blair, 1952, noting that, quote, the presidential electors exercise a federal function, end quote. Burroughs v. United States, 1934, stating that electors, quote, exercise federal functions under and discharge duties in virtue of authority conferred by the Constitution of the United States, end quote. United States v. Brock, 2024, noting the, quote, unique congressional function of certifying electoral college votes, end quote. Indeed, Mr. Trump never challenged the indictment on that basis, though he filed more than 100 pages in support of dismissal motions. As the Court of Appeals found in the context of the immunity litigation in this case, quote, former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government, end quote. United States v. Trump, 2024, vacated and remanded on other grounds, 2024. Mr. Trump also sought to obstruct the certification. His sole objective was to ensure that no one other than himself was certified as the president. Nor is there any doubt that Mr. Trump conspired with others to achieve his goal and that at least one overt act was committed. With 3 of the 4 elements of a Section 371 violation established, the office anticipated that a central dispute at trial would be whether Mr. Trump pursued his obstructive pursuit by, quote, deceit, craft, or trickery, or at least by means that are dishonest, end quote. Hammerschmidt. The office concluded that the evidence established beyond a reasonable doubt that he did. The core of Mr. Trump's obstructive scheme was a false narrative of outcome-determinative voter fraud, which he and his surrogates frequently repeated and widely disseminated over the course of 2 months. Crucially, not only was Mr. Trump's voter fraud claim narrative objectively false, he knew that it was false. Mr. Trump's false claims were repeatedly debunked, often directly to him by the very people best positioned to ascertain their truth. Campaign personnel told Mr. Trump his claims were unfounded. So did state officials, a White House official who engaged with Mr. Trump in his capacity as a candidate, and even his own running mate. For example, Mr. Trump's campaign manager informed him that a claim that had been circulating, that a substantial number of non-citizens had voted in Arizona, was false. State officials issued public statements dispelling Mr. Trump's claims of widespread election fraud. Georgia's Secretary of State refuted multiple false claims of election fraud directly to Mr. Trump, including the false allegation that 5,000 dead people had voted in Georgia. When Mr. Trump raised various fraud allegations with Michigan's Senate Majority Leader, he was told that he had lost because he had underperformed with educated females. Vice President Pence told Mr. Trump that he had seen no evidence of outcome-determinative fraud in the election. And, tellingly, a senior advisor reiterated to Mr. Trump that co-conspirator 1 would be unable to prove his false fraud allegations in court, to which Mr. Trump responded, quote, the details don't matter, end quote. Courts in which Mr. Trump brought numerous lawsuits all rebuffed his claims, which in some instances prompted him to issue public rebukes acknowledging those decisions. Still other federal and state officials, some appointed by Mr. Trump and others who publicly supported and voted for him, publicly debunked allegations of outcome-determinative voter fraud. Mr. Trump did not reach out to any of these officials to ask relevant questions about the election because he was not seeking honest answers. This was a pattern revealed throughout the investigation. Mr. Trump unquestioningly accepted at face value and amplified election fraud claims that benefited his quest to retain power. Conversely, he avoided consulting informed sources such as state election officials who possessed evidence that could debunk his claims. The office concluded that this consistent pattern would constitute powerful proof at trial that Mr. Trump knew the claims he was making were false. Mr. Trump's false claims were often divergent from one day to the next and otherwise internally inconsistent. For example, in Arizona, the conspirators started with the allegation that 36,000 non-citizens voted in that state. 5 days later, it was, quote, beyond credulity that a few 100,000 didn't vote, end quote. 3 weeks later, quote, the bare minimum was 40 or 50,000. The reality is about 250,000, end quote. Days after that, the assertion was 32,000, and ultimately, the conspirators landed back where they started at 36,000, a false figure that they never verified or corroborated. And in Georgia, the conspirators initially suggested that a large enough number of dead voters had cast ballots to overcome Mr. Trump's losing margin of about 12,000 voters. 1 month later, the number was 10,315. 3 days after that, the assertion was, quote, close to 5,000 people, end quote, and then 2 days later, the number bounced back to 10,315. Mr. Trump bears legal responsibility for each of these false claims because they were made by him and his co-conspirators in furtherance of the conspiracy that he led. See Salinas v. United States, 1997, quote, the partners in the criminal plan must agree to pursue the same criminal objective and may divide up the work, yet each is responsible for the acts of each other, end quote. See also Federal Rules of Evidence 801 D2E, statement by an opposing party's, quote, conspirator during and in furtherance of the conspiracy, end quote, is admissible against that party. United States v. Brockenborough, 2009, United States v. Tarantino, 1988. The office developed further evidence of Mr. Trump's knowledge that his claims were untrue from witnesses who reported that he planned to use fraud claims before the election had even happened. For instance, in advance of the election, advisors told Mr. Trump that the election would be close and that initial returns might be misleading, showing an early lead for Mr. Trump that would diminish as mail-in ballots were counted. In response, Mr. Trump suggested that if that prediction were true, which it ultimately was, he would simply declare victory before all ballots were counted and a winner was projected. He also made repeated public statements in the lead-up to Election Day in which he sowed public doubt in the election results, setting the stage for his later fraud claims. And Mr. Trump made his first statement claiming fraud in the election only hours after polls closed, when no investigations had begun, much less concluded. Mr. Trump's intent in spreading knowing falsehoods was further evidenced by statements he made to those around him. In private, in contrast with his public false claims, Mr. Trump made admissions that reflected his understanding that he had lost. In a private moment, Mr. Trump confessed to his family members that, quote, it doesn't matter if you won or lost the election. You still have to fight like hell, end quote. When President-elect Biden appeared on television in November, Mr. Trump said to a staffer, quote, can you believe I lost to this effing guy? End quote. And when his own vice president declined to join the conspiracy, Mr. Trump berated him for being, quote, too honest. Because the evidence showed that Mr. Trump knew his claims were false, it amply satisfied the mens rea standard for a Section 371 charge, which would be satisfied by evidence that Mr. Trump either knew his fraud claims were false or that he acted with deliberate disregard for their truth or falsity. The concept of deliberate disregard, sometimes referred to as reckless disregard or reckless or deliberate indifference, has deep roots in the law of fraud. See U.S. Ex Rel. Shute v. SuperValue, Inc., 2023. Story, Commentaries on Equity Jurisprudence, 10th edition, 1870, quote, whether the party, thus misrepresenting a material fact, knew it to be false or made the assertion without knowing whether it were true or false, is wholly immaterial. For the affirmation of what one does not know or believe to be true is equally, in morals and law, as unjustifiable as the affirmation of what is known to be positively false." End quote. That concept is reflected in case law and jury instructions for the District of Columbia, as well as precedent from every other circuit. See e.g. United States v. Philip Morris USA, Inc., 2009. 1. Criminal Jury Instructions for the District of Columbia, 5.200, 2024. Here, the evidence showed that Mr. Trump decided, even before the election, that he would allege outcome-determinative fraud, whether it occurred or not, if he were not declared the winner, and he adhered to that plan, repeating false claims that he knew to be untrue. Although Mr. Trump's conduct fell comfortably within the established elements of a defraud clause offense, the office noted that the Supreme Court has, in several recent decisions, limited the reach of other federal fraud and obstruction statutes. C.e.g. Simonelli v. United States, 2023. Reversing conviction of construction contractor for wire fraud, 18 U.S.C. Section 1343, for scheming with public official to tailor bid requirements for government contracts to favor himself because the government did not prove the defendant deprived the victim of a traditional property interest. Kelly v. United States, 2020, reversing convictions for wire fraud, 18 U.S.C. Section 1343, and federal program fraud, 18 U.S.C. Section 666, where defendants aimed to inflict political retribution on mayor by closing lanes of a bridge that served the mayor's city because the object of the scheme was not to obtain money or property. Skilling v. United States, 2010, paring back honest services fraud statute, 18 U.S.C. Section 1346, to reach only core bribery and kickbacks, and reversing conviction of executive who was convicted of making false statements to inflate his company's value, but was not alleged to have taken bribes or kickbacks for his efforts. Arthur Anderson, LLP v. United States, 2005. Requiring showing of knowingly corrupt conduct under obstruction of justice statute, 18 U.S.C. Section 1512, and reversing conviction of accounting firm convicted of shredding documents in advance of an SEC investigatory demand based on failure of jury instructions to convey the requisite consciousness of wrongdoing. Given these decisions restricting the reach of other fraud and corruption statutes, the office considered whether the Supreme Court might also adopt a new construction of the defraud clause in Section 371, such as one that would for the first time limit it to money or property fraud. The office concluded, however, that the creation of such a new rule would not be supported in the law, given that the well-established elements of a defraud clause offense are firmly grounded in the statute's text, history, and long-standing judicial precedent. For more than 100 years, the Supreme Court has, quote, stated repeatedly that the fraud covered by the statute reaches any conspiracy for the purposes of impairing, obstructing, or defeating the lawful function of any department of government, end quote, and that this branch of liability is distinct from money or property limitations in other areas of fraud law. Tanner v. United States, 1987. C. Dennis v. United States, 1966, quote, it has long been established that this statutory language is not confined to fraud as that term has been defined in the common law. It reaches any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department in government, end quote. Glasser v. United States, 1942, upholding prosecution of a federal prosecutor for conspiring to receive bribes to influence his official duties. No financial fraud against the United States alleged. Quote, the indictment charges that the United States was defrauded by depriving it of its lawful governmental functions by dishonest means. It is settled that this is a defrauding within the meaning of Section 37 of the Criminal Code. End quote. The predecessor to Section 371. Hammerschmidt, Quote, to conspire to defraud the United States also means to interfere with or obstruct one of its lawful governmental functions by deceit, craft, or trickery, or at least by means that are dishonest. It is not necessary that the government shall be subjected to property or pecuniary loss by the fraud, but only that its legitimate official action and purpose shall be defeated by misrepresentation, chicane, or the overreaching of those charged with carrying out the governmental intention. End quote. Haas v. Henkel, 1910, quote, it is not essential that such a conspiracy shall contemplate a financial loss or that one shall result. The statute is broad enough in its terms to include any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. End quote. Against the backdrop of that Supreme Court precedent, Congress has reenacted and indeed expanded the scope of the defraud clause, reflecting congressional ratification of the court's construction of it. See e.g. Forest Grove School District v. 2009, quote, Congress is presumed to be aware of an administrative or judicial interpretation of a statute and to adopt that interpretation when it reenacts a statute without change. End quote. In 1948, for instance, when Congress codified the General Conspiracy Statute, 18 U.S.C. Section 371, where the defraud clause currently resides, it was already settled that, quote, defrauding the United States by depriving it of its lawful governmental functions by dishonest means is a defrauding within the meaning of, end quote, the defraud clause, Glasser, and at that time Congress added the words, quote, or any agency thereof, end quote, in the defraud clause after United States. The House report from the Judiciary Committee accompanying the pertinent bill specifically stated that the amendment was designed, quote, to reflect the construction placed upon the predecessor statute by the courts, end quote. And it has consistently been the Department's position in litigation that the defraud clause proscribes conspiracies to obstruct a lawful function of the federal government through deceit. See e.g. Gaspipe Inc. v. United States, 2021, stating petitioner's contention that defraud clause is limited to money and property schemes, quote, is inconsistent with over a century of Supreme Court precedent, end quote. Flynn v. United States, 2021, stating defraud clause is not unconstitutionally vague in part because of the Supreme Court's long-standing interpretation that interference or obstruction must be by deceit or dishonest means. Copland v. United States, 2013, explaining that petitioners claim that the decisions in mail and wire fraud cases, like McNally v. United States, 1987, and Skilling undermine, quote, long-standing, congressionally adopted construction of the defraud clause, end quote, is erroneous and misplaced and, quote, disregards important limitations inherent in the defraud clause, end quote, including the requirement that, quote, a conspiracy under the defraud clause must be deceptive or deceitful, end quote. Accordingly, the office concluded that Mr. Trump's conduct fell within the scope of Section 371, given the statute's long-standing, congressionally ratified construction and its historic use by the Justice Department. The office also recognized various limiting principles in the application of Section 371 that separate Mr. Trump's conduct from mere hardscrabble politics. A defraud clause violation, as honed by years of judicial decisions, including repeated applications by the Supreme Court, requires not only an agreement among co-conspirators, but identification of a specific function of the federal government, the intent to obstruct that function through deceit, and an overt act. See e.g. United States v. Johnson, 1966. In exchange for undisclosed campaign contributions and legal fees, congressmen conspired to defeat the lawful functions of the Department of Justice by urging dismissal of pending indictments. First, a defraud clause conspiracy must be targeted at a lawful function of the United States or any agency thereof. See e.g. United States v. Haldeman, 1976, quote, The unlawful agreement to attempt to use the CIA to interfere with the investigation of the Watergate break-in was thus fairly charged in Count 1 of the indictment as one of the means by which the defendants intended to accomplish one of the principal objects of their conspiracy, defrauding the United States of its right to have its officials and agencies transact their business honestly, impartially, and free from corruption or undue influence or obstruction." End quote. In contrast, a conspiracy targeted at a private party or at a state or local government does not suffice, even if the entity receives federal funds or, quote, serves as an intermediary performing official functions on behalf of the federal government, end quote. Tanner. Second, obstruction of the governmental function must be, quote, a purpose or object of the conspiracy and not merely a foreseeable consequence of the conspiratorial scheme, end quote. United States v. Goldberg, 1997. Thus, for example, financial crimes do not, quote, automatically become federal conspiracies to defraud the IRS, end quote, simply because the crime may have foreseeable tax implications. And this requirement means that the conspiracy must be aimed at defeating and obstructing the government function rather than simply participating in it. Third, the defraud clause, quote, is limited only to wrongs done by deceit, craft, or trickery, or at least by means that are dishonest, end quote. Hammerschmidt. Fourth, the overt act requirement provides another limitation, the function of which is, quote, to manifest that the conspiracy is at work and is neither a project still resting solely in the minds of the conspirators nor a fully completed operation no longer in existence. Yates v. United States, 1957. Overruled on other grounds by Burks v. United States, 1978. Finally, while a court in the District of Columbia has stated that materiality is not an element of a defraud clause conspiracy, see Concord Management and Consulting LLC, the office was prepared to prove the materiality of Mr. Trump's deceptive statements and to offer a materiality instruction as another limitation on the scope of Section 371. Under that limitation, even conspirators who make knowingly false statements with an obstructive intent will not violate the defraud clause unless their statements are material. All of these requirements for establishing a conspiracy to defraud under Section 371, taken collectively, ensure that common political conduct or political speech does not fall within the scope of the defraud clause. The evidence collected during the investigation met these requirements as to Mr. Trump's conduct. B. Obstruction and conspiracy to obstruct, 18 U.S.C. Section 1512K and C2. The federal statute prohibiting obstruction of an official proceeding makes it a crime to, quote, corruptly alter, destroy, mutilate, or conceal a record, document, or other object, or attempt to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or 2, otherwise obstruct, influence, or impede any official proceeding or attempt to do so, end quote. 18 U.S.C. Section 1512C. A separate provision defines the term official proceeding to include, quote, a proceeding before Congress, end quote. 18 U.S.C. Section 1515 A1B. In Fisher v. United States, 2024, decided during the pendency of Mr. Trump's immunity appeal, the Supreme Court clarified the scope of an obstruction offense under Section 1512C2, holding that the statute applies only when a defendant impairs or attempts to impair, quote, the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in the proceeding, end quote. Ibid. In language that applies directly to the allegations in the superseding indictment, the Supreme Court explained that Section 1512C2's criminal prohibition includes, quote, creating false evidence. Ibid. Before seeking the original indictment, which, like the superseding indictment, alleged that one component of Mr. Trump's and his co-conspirators' obstruction involved replacing valid elector certificates from the contested states with false ones they had manufactured, The office anticipated the possibility of such a result in Fisher and confirmed that the evidence would prove Mr. Trump's guilt beyond a reasonable doubt, even under a narrow interpretation of Section 1512c2. In construing Section 1512c2 to reach impairing or attempting to impair the integrity or availability of records, documents, or other objects through, quote, creating false evidence, the Supreme Court cited United States v. Reich, 2007, Sotomayor, in which a defendant was convicted under Section 1512c2 after he forged a court order and sent it to an opposing party, intending to cause that party to withdraw a mandamus petition then pending before an appellate court. Just as the defendant in Reich violated Section 1512c2 by, quote, injecting a false order into ongoing litigation to which he was a party, end quote, ibid, the evidence showed that the co-conspirators created fraudulent electoral certificates that they intended to introduce into the congressional certification proceeding on January 6th to obstruct it. The office was also prepared to prove that Mr. Trump willfully caused his supporters to obstruct and attempt to obstruct the proceeding by summoning them to Washington, D.C., and then directing them to march to the Capitol to cause the vice president and legislators to reject the legitimate certificates and instead rely on the fraudulent electoral certificates. See 18 U.S.C. Section 2B, making a defendant criminally liable for, quote, willfully causing an act to be done which, if directly performed by him or another, would be, end quote, a federal offense. United States v. Hesea, 1999, upholding a conviction for willfully causing a violation of 18 U.S.C. Section 1001. The Supreme Court's opinion in Fisher, therefore, did not undermine the viability of the Section 1512 counts. Much of the evidence that supports the Section 371 conspiracy to defraud likewise proves that Mr. Trump and co-conspirators violated Section 1512K and Section 1512C2. To demonstrate a violation of Section 1512C2 following Fisher, the government must prove 1. The defendant obstructed, influenced, or impeded an official proceeding or attempted to do so. 2. In the course of doing so, the defendant committed or attempted to commit an act that impaired the integrity or rendered unavailable documents, records, objects, or other things for use in the official proceeding. 3. The defendant intended to impair the integrity of or render unavailable such records, documents, objects, or other things for use in the official proceeding. And 4. The defendant acted corruptly. See United States v. Baez, 2024, describing elements required to establish a violation of Section 1512c2 following Fisher. Mr. Trump's conduct establishes each of these elements beyond a reasonable doubt. The congressional certification proceeding was an official proceeding for purposes of Section 1512. As every district court judge in the District of Columbia to have considered this question has concluded, see United States v. Bingert, 2022, and as the D.C. Circuit has agreed, see Fisher, 2023, vacated and remanded on other grounds, 2024, the evidence described above supporting the Section 371 charge also establishes Mr. Trump's knowingly obstructive conduct. And as described above, Mr. Trump willfully caused others to attempt to obstruct the certification proceeding on January 6th. Finally, the government was prepared to prove Mr. Trump's corrupt intent under any definition beyond a reasonable doubt. To act corruptly means 1. Acting dishonestly, 2. Intending the use of unlawful means, 3. Violating a legal duty or causing or seeking to cause someone else to violate a legal duty, or 4. Seeking an unlawful or improper benefit or advantage. Acting corruptly also means acting with consciousness of wrongdoing. See United States v. Robertson, 2023, United States v. Morrison, 1996, Arthur Anderson, LLP, 2005. Mr. Trump and co-conspirators used deceptive and dishonest means. He intended the use of independently criminal means to obstruct the congressional certification proceeding. He and co-conspirators plainly sought to cause state and federal officials to violate a legal duty, and Mr. Trump acted, quote, with an intent to procure an unlawful benefit either for oneself or for some other person, end quote. Fisher. Most basically, Mr. Trump sought, quote, unlawfully to secure a professional advantage, the presidency, end quote, ibid, to which he was not lawfully entitled. C. Conspiracy against rights, 18 U.S.C. Section 241. Section 241 makes it unlawful for two or more persons to, quote, conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, end quote. A violation of Section 241 requires proof of three elements. 1. Mr. Trump entered into a conspiracy. 2. To willfully injure, oppress, threaten, or intimidate a person in the United States. 3. In the exercise or enjoyment of a right secured by the Constitution or federal law. 18 U.S.C. Section 241, see e.g. United States v. Epley, 1995. Mr. Trump's conduct meets each element. The right to vote for president, based on the determination by state legislatures to appoint electors based on their constituents' votes, is, quote, fundamental. Bush v. Gore, 2000. C.F. Burdick v. Takushi, 1992, quote, the right to vote is the right to participate in an electoral process that is necessarily structured to maintain the integrity of the democratic system, end quote. United States v. Robertson, 2016. Section 241, quote, prohibits interference with a voter's right to cast a ballot for his or her preferred candidate and prohibits interference with the right of voters to have their votes free from dilution by unlawfully procured votes, end quote. It is a right rooted in the principles of accountability to and consent by the governed, which has distinguished this nation from its founding. As the Supreme Court has recognized, quote, the right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any restrictions on that right strike at the heart of representative government, end quote. Reynolds v. Sim, 1964. See also Yickwo v. Hopkins, 1886. Voting is, quote, regarded as a fundamental political right because it is preservative of all rights, end quote. Wesbury v. Sanders, 1964, quote, no right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even the most basic, are illusory if the right to vote is undermined, end quote. Mr. Trump acknowledged that voting in a presidential election is a fundamental right under the Constitution. See ECF number 163 at 23, arguing that, quote, urging states or Congress to use their power to select or to count electors does not affect the fundamental right to vote because it does not arbitrarily value one person's vote over that of another, Bush, or restrict the exercise of that right. Rather, it encourages the states and Congress to exercise their constitutional prerogatives in a certain way, end quote. Indeed, given that all states have made the popular vote an integral means of appointing electors, the right to vote in a presidential election is among the most precious federal rights protected by the Constitution. Cf. United States v. Classic, 1941. When a state makes a primary election, quote, an integral part of the procedure for the popular choice of a congressman, end quote, it becomes, quote, a right established and guaranteed by the Constitution, end quote. See also Trump v. Anderson, 2024, per curiam, noting the, quote, uniquely important national interest, end quote, in a presidential election because, quote, the president represents all the voters in the nation, end quote. The history of the Section 241 offense with which Mr. Trump was charged, along with courts' universal and long-standing recognition of the voting rights protected by that statute, confirm that protecting the right to vote is critical to the existence of the right. Section 241's predecessor statute was passed as part of the Enforcement Act of 1870, a Reconstruction-era law to address the continued denial of rights to black citizens, sometimes accompanied by violent assaults. United States v. Price, 1966. That act sought to combat widespread anti-Reconstruction violence, which included acts of terror aimed at disenfranchising black voters. The same year as the Act's passage, Congress established the U.S. Department of Justice, and the department zealously pursued its mission to enforce voting rights in the Reconstruction era. Through the application and interpretation of Section 241 and its predecessor statute, courts have repeatedly underscored the importance of the right to vote. Courts have held that the right encompasses the ability to cast a vote, Ex parte Yarbrough, the Ku Klux cases, 1884, protecting the right of an emancipated person to vote, and to have that vote counted. United States v. Mosley, 1915, quote, "We regard it as equally unquestionable that the right to have one's vote counted is as open to protection by Congress as the right to put a ballot into a box." End quote. They have further confirmed that one's vote cannot lawfully be denied, destroyed, or diluted. See e.g. Classic, holding that Section 241's predecessor statute applied to conspiracies to prevent the official counting of ballots in a primary election. United States v. Saylor, 1944. Section 241 applies to prohibit conspiracies to dilute legitimate votes by stuffing the ballot box. United States v. Pleva, 1933. Board of Elections inspectors charged with falsely tabulating ballots to favor certain candidates, convictions reversed on separate jury grounds. United States v. Skurla, 1954. Defendants charged for casting and causing to be cast false and forged ballots, causing an incorrect vote tally, and using unqualified individuals to impersonate lawful voters. United States v. Townsley, 1988, scheme to discard certain absentee ballots. Mr. Trump and co-conspirators sought to deprive, that is, injure or oppress, citizens of their constitutional right to have their presidential election votes counted. The words injure or oppress in Section 241 are not used in any technical sense, but cover a variety of conduct intended to prevent, harm, inhibit, hinder, frustrate, obstruct, or interfere with the free exercise and enjoyment of a right. See United States v. Handy, 2023, United States v. Mackey, 2023. Although they were not in a back room altering the vote tallies in a local election or stuffing falsified ballots into the ballot boxes, as alleged in prior cases charged under this statute, Mr. Trump and co-conspirators nonetheless sought the same result: to effectively cast aside legitimate votes in a manner that would have deprived citizens of their right to vote and have their votes counted. As co-conspirator 1 admitted, their primary objective was to, quote, just flat out change the vote, deduct that number of votes from the, declare those votes, 300,000 votes in Philadelphia, illegal, unlawful, reduce the number by 300,000, end quote. Mr. Trump attempted to carry out this objective in multiple ways. He urged state officials to disregard the legitimate majority of votes for Mr. Biden and pressured and threatened Georgia's Secretary of State to, quote, find more than 11,000 votes to dilute Mr. Biden's vote count in the state. And he urged Mr. Pence to disregard the legitimate electoral certificates that reflected millions of citizens' votes in the targeted states. The evidence collected showed that Mr. Trump targeted this voting right with precision. He centered his false claims of election fraud on selected states or cities and counties within those states with large numbers of voters who had not chosen to re-elect him. D. Defenses. Before presenting the original indictment to the grand jury, the office considered Mr. Trump's potential defenses to these charges, including a good faith defense, an advice of counsel defense, and constitutional defenses. The office concluded that each of the defenses was legally or factually flawed and thus would not prevail. First, it was expected that Mr. Trump would argue that he acted in good faith when he sought to stop the transfer of presidential power because he genuinely believed that outcome determinative fraud had undermined the election's integrity and caused him to lose. As set forth above in Section 2A, the office developed strong proof that Mr. Trump knew that his election fraud claims were false. For example, Mr. Trump made persistent claims of a large number of dead voters in Georgia, including in his speech at the Ellipse on January 6th, even though his senior campaign advisor and Georgia's Secretary of State had told him that the claims were untrue. He spread lies, including in his Ellipse speech, of sinister, fraudulent vote dumps in Michigan, even after Michigan's Senate Majority Leader told him that nothing suspicious had occurred. And Mr. Trump repeatedly made provably false allegations about fraud in Pennsylvania, despite having been told by the chairman of the state Republican Party that the vote count was occurring as expected. Even if Mr. Trump maintained that he sincerely believed he won the election, a conclusion unsupported by the evidence collected in the investigation, it would not provide a defense to the Section 371 charge. A defendant may not use deceit to obstruct a government function, even if he believes the function itself to be unconstitutional because, quote, a claim of unconstitutionality will not be heard to excuse a voluntary, deliberate, and calculated course of fraud and deceit. End quote. Dennis. Quote, one who elects such a course as a means of self-help may not escape the consequences by urging that his conduct be excused because the statute which he sought to evade is unconstitutional. End quote. Ibid. There are, quote, appropriate and inappropriate ways to challenge perceived illegalities. Ibid. Just as the president of a company may be guilty of fraud for using knowingly false statements of fact to defraud investors, even if he subjectively believes that his company will eventually succeed, see e.g. United States v. Arif, 2018, United States v. Kennedy, 2013, United States v. Chavez, 2006, Mr. Trump could be convicted of using deceit to obstruct the government function by which the results of the presidential election are collected, counted, and certified, even if he established that he subjectively believed that he had reason to do so because of his claims that the election was rigged. It bears emphasis that Mr. Trump's knowing deceit was pervasive throughout the charged conspiracies. This was not a case in which Mr. Trump merely misstated a fact or two in a handful of isolated instances. On a repeated basis, he and co-conspirators used specific and knowingly false claims of election fraud in his calls and meetings with state officials in an effort to induce them to overturn the results of the election in their states, to his own vice president to induce Mr. Pence to violate his duty during the congressional certification proceeding, and on January 6th as a call to action to the angry crowd he had gathered at the Ellipse and sent to the Capitol to disrupt the certification proceeding. Mr. Trump and co-conspirators used other forms of deceit as well, including when they falsely represented that the fraudulent electoral votes would be used only if Mr. Trump prevailed in pending contests in their states, and when they caused the fraudulent electors to falsely swear that they were duly certified and send those false certifications to Congress. Regardless of any claim that Mr. Trump subjectively believed the outcome of the election was unfair or rigged, the office concluded that these knowingly deceitful statements and acts would overcome any good-faith defense. The office also expected that Mr. Trump might claim that his consultation with attorneys, several of whom were co-conspirators, should negate a finding that he acted with a criminal state of mind. In pretrial litigation, the court granted the government's motion that Mr. Trump should be required to declare whether he intended to employ such a defense, and, if he did, to produce the discovery required by the attendant waiver of Mr. Trump's attorney-client privilege. A defendant's claim that he relied in good faith on his attorney's advice is, quote, not an affirmative defense that defeats liability even if the jury accepts the government's allegations as true, end quote, but functions instead as, quote, evidence that, if believed, can raise a reasonable doubt in the minds of the jurors about whether the government has proved the required element of the offense that the defendant had an unlawful intent, end quote. United States v. Scully, 2017, quoting United States v. Beechnut Nutrition Corporation, 1989. Under D.C. Circuit law, an advice of counsel defense consists of two elements. The defendant, one, quote, relied in good faith on the counsel's advice that his course of conduct was legal, end quote, and two, quote, made full disclosure of all material facts to his attorney before receiving the advice at issue, end quote. United States v. Gray-Burris, 2019, quoting United States v. DeFries, 1997. The office concluded that if Mr. Trump chose to raise such a defense, it would fail because an advice of counsel defense is not available, quote, where counsel acts as an accomplice to the crime, end quote. United States v. West, 2004. The evidence showed that the central attorneys on whom Mr. Trump may have relied for such a defense, such as co-conspirator 1 or co-conspirator 2, were, quote, partners in a venture, end quote, with the result that any advice of counsel defense necessarily would fail. Ibid, citing United States v. Carr, 1984, cf. United States v. Sintolo, 1987, quote, a criminal lawyer has no license to act as a lawyer criminal, end quote. Co-conspirator 1 assisted Mr. Trump in using knowingly false claims of election fraud in furtherance of the charged conspiracies. At press conferences, at hearings before legislatures in the targeted states, and directly with officials in the targeted states, co-conspirator 1 made a wide range of specific, though ever-changing, false claims of election fraud. Co-conspirator 1 continued to do so after his lies were publicly or directly debunked. Co-conspirator 1's involvement spanned from his insistence that Mr. Trump declare victory on election night to the voicemails that co-conspirator 1 left for senators on the night of January 6th, using false claims of election fraud to ask that the legislators further delay the certification. Co-conspirator 2 was instrumental in Mr. Trump's efforts to organize his electors to cast fraudulent votes and send them to the vice president, and then to pressure the vice president to use the fraudulent electoral certificates to overturn the election results. Throughout his involvement in Mr. Trump's conspiracies, co-conspirator 2 conceded privately to other attorneys, both private attorneys and those responsible for advising Mr. Trump and the vice president, that his plans violated federal law and would not withstand scrutiny in court. Furthermore, Mr. Trump could not have succeeded in showing that he relied in good faith on legal advice from these attorneys. The evidence showed that Mr. Trump was not looking to co-conspirator 1 or co-conspirator 2 for legal advice. Instead, Mr. Trump was the head of a conspiracy who sought legal cover from his co-conspirators. As co-conspirator 1 acted repeatedly in furtherance of the conspiracies, multiple advisors to Mr. Trump warned him that co-conspirator 1 would not successfully challenge the election results and was not acting in Mr. Trump's best interest. Mr. Trump ignored them all because he was not relying on co-conspirator 1 as an attorney. Similarly, co-conspirator 2's willingness to advocate for actions that he knew and even privately conceded were unlawful demonstrates that both he and Mr. Trump understood his role was not that of an attorney offering legal advice on which Mr. Trump was acting. For instance, in a lawsuit in Georgia, co-conspirator 2 filed a false certification by Mr. Trump after having written to other attorneys in an email that both he and Mr. Trump knew some of the allegations incorporated in the filing were inaccurate. And co-conspirator 2's decision to advocate to the vice president's counsel and chief of staff on January 5, 2021, that the vice president should unlawfully reject legitimate electoral certificates, an act that co-conspirator 2 had previously recognized was not supported by the Constitution or federal law, was a sharp reversal from his position just 1 day earlier, and happened only because Mr. Trump had made clear that it was his preferred strategy. The office was otherwise confident that it would be able to demonstrate that, with respect to all attorneys, Mr. Trump could not meet the elements of the defense, such as the requirement that he make full disclosure to any attorneys of all relevant facts and then rely faithfully on their service. See Gray-Burris. Finally, the office anticipated that Mr. Trump would claim that his conduct was protected by the First Amendment. As the district court recognized, quote, "The First Amendment embodies our profound national commitment to the free exchange of ideas," end quote, and it bars the government from, quote, "restricting expression because of its message, its ideas, its subject matter, or its content," end quote. ACF number 171 at 31, quoting Ashcroft v. American Civil Liberties Union, 2002, and United States v. Stevens, 2010. At the same time, quote, "It is well established that the First Amendment does not protect speech that is used as an instrument of a crime," end quote, Ibid. Quote, "Many long-established criminal laws permissibly criminalize speech that is intended to induce or commence illegal activities." United States v. Williams, 2008, such as fraud, bribery, perjury, extortion, threats, incitement, solicitation, and blackmail. See e.g. Stevens, fraud, Williams, incitement, solicitation, Citizens United v. Federal Election Commission, 2010, bribery, Rice v. Paladin Enters, Incorporated, 1997, extortion, threats, blackmail, perjury. End quote. ACF number 171, 31-32. Quote, "Prosecutions for conspiring, directing, and aiding and abetting do not run afoul of the Constitution when those offenses are carried out through speech," end quote. Ibid. At 32, quoting National Organization for Women v. Operation Rescue, 1994, and citing Williams. Consistent with that precedent, the original and superseding indictments recognized that Mr. Trump, quote, "had a right, like every American, to speak publicly about the 2020 presidential election and even to claim, falsely, that there had been outcome-determinative fraud during the election and that he had won," end quote. They charged Mr. Trump, however, with using knowingly false statements to defeat a government function, injure the right to vote, and obstruct an official proceeding. That is, he made, quote, "dozens of specific claims that there had been substantial fraud in certain states, such as that large numbers of dead, non-resident, non-citizen, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes for Biden." Those were factual claims that were verifiably false, and Mr. Trump knew that they were false. See Ibid. Mr. Trump then used those lies as the instruments of his 4 criminal offenses. Because he used those knowingly false statements regarding specific facts to commit the crimes charged in the superseding indictment, they were not protected by the First Amendment. See Stevens, including fraud in the list of well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. United States v. Nordine, 2021, quote, "By focusing on corrupt actions, Section 1512c2 does not even reach free speech," end quote. See also United States v. Alvarez, 2012, plurality opinion, explaining that while, quote, "falsity alone may not suffice to bring the speech outside the First Amendment," end quote, the First Amendment permits criminal laws that proscribe knowing or reckless falsehoods in connection with some, quote, "other legally cognizable harm," end quote, including, quote, "protecting the integrity of government processes," end quote. In pretrial motions, Mr. Trump moved to dismiss the original indictment based on the First Amendment. The office filed an opposition brief, and the district court denied the motion, finding that the indictment, quote, "properly alleges defendants' statements were made in furtherance of a criminal scheme." As the court explained, Mr. Trump was, quote, "not being prosecuted for his view on a political dispute. He was being prosecuted for acts constituting criminal conspiracy and obstruction of the electoral process," end quote. Ibid, and the fact that his, quote, "alleged criminal conduct involved speech does not render the indictment unconstitutional," end quote. Ibid, because he was, quote, not being prosecuted simply for making false statements, but rather for knowingly making false statements in furtherance of a criminal conspiracy and obstructing the electoral process, end quote, there was, quote, no danger of a slippery slope in which inadvertent false statements alone are alleged to be the basis for criminal prosecution, end quote. Ibid. See generally Ibid, rejecting other First Amendment claims. E. Other charges. The office considered but ultimately opted against bringing other charges. One potential charge was 18 U.S.C. 2383, sometimes referred to as the Insurrection Act, which provides that, quote, whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States, end quote. 18 U.S.C. Section 2383. Section 2383 originated during the Civil War as part of the Second Confiscation Act of 1862. Cases interpreting Section 2383 are scarce and arose in contexts that provided little guidance regarding its potential application. In this case, see e.g. United States v. Greathouse, 1863, construing the original version of the Act to encompass treason consisting of arming a vessel to commit hostilities against United States vessels in the context of the rebellion by the Confederate States, United States v. Cathcart, 1864, rejecting legal argument that treason against the United States was legally impossible in the context of the rebellion by the Confederate States. In Re Grand Jury, 1894, grand jury charge describing offense in the context of a labor dispute involving interference with transportation of the mail. In Re Charge to Grand Jury, 1894, grand jury charged that, quote, insurrection is a rising against civil or political authority, end quote, and requires, quote, such a number of persons as would constitute a general uprising in that particular locality, end quote, in the context of offense of obstructing the mails. It does not appear that any defendant has been charged with violating the statute in more than 100 years. To establish a violation of Section 2383, the office would first have had to prove that the violence at the Capitol on January 6, 2021, constituted an, quote, insurrection against the authority of the United States or the laws thereof, end quote, and then prove that Mr. Trump, quote, incited or, quote, assisted the insurrection or, quote, gave aid or comfort thereto, end quote. 18 U.S.C. Section 2383. Courts have found or described the attack on the Capitol as an insurrection. In Anderson v. Griswold, 2023, reversed on other grounds, sub nom, Trump v. Anderson, 2024, per curiam, the Colorado Supreme Court found that Mr. Trump engaged in an insurrection as that term is used in Section 3 of the 14th Amendment. Federal courts in the District of Columbia have also used the term insurrection to describe the attack on the Capitol, but did so in cases where there was no criminal charge under Section 2383. See e.g. United States v. Chweiswick, 2023, quote, as this court and other courts in the United States District Court for the District of Columbia have stated previously, what occurred on January 6, 2021 was in fact an insurrection and involved insurrectionists, and therefore the terms to which defendants object are accurate descriptors. United States v. Carpenter, 2023, quote, what occurred on January 6th was in fact a riot and an insurrection, and it did in fact involve a mob. End quote. See also United States v. Monchel, 2021, using the term, quote, insurrection in a case that did not involve Section 2383. These cases, however, did not require the courts to resolve the issue of how to define insurrection for purposes of Section 2383 or apply that definition to the conduct of a criminal defendant in the context of January 6th. The office recognized why courts described the attack on the Capitol as an insurrection, but it was also aware of the litigation risk that would be presented by employing this long-dormant statute. As to the first element under Section 2383, proving an, quote, insurrection against the authority of the United States or the laws thereof, end quote, the cases the office reviewed provided no guidance on what proof would be required to establish an insurrection or to distinguish an insurrection from a riot. Generally speaking, quote, an insurrection is a rising against execution of law in a city or state, end quote. In recharge to grand jury, see also insurrection, Merriam-Webster, quote, an act or instance of revolting against civil authority or an established government, end quote. Insurrection, American Heritage Dictionary, 2000, quote, the act or instance of open revolt against civil authority or a constituted action of rising in arms or open resistance against established authority or governmental restraint, end quote. Some sources distinguish an insurrection from a rout, riot, or offense connected with mob violence by the fact that in insurrection there is an organized and armed uprising against authority or operations of government, while crimes growing out of mob violence, however serious they may be and however numerous the participants, are simply unlawful acts in disturbance of the peace which do not threaten the ability of the government or the existence of political society. Black's Law Dictionary, 1994. See also Anderson, noting Mr. Trump's argument that, quote, an insurrection is more than a riot but less than a rebellion, and agreeing that an insurrection falls along a spectrum of related conduct. In case law interpreting insurrection in another context, one court has observed that an insurrection typically involves overthrowing a sitting government rather than maintaining power, which could pose another challenge to proving beyond a reasonable doubt that he was the sitting president at that time. Cf. Citgo Petroleum Corporation v. Starstone Insurance S.E., 2023. Quote, in every case over the course of over 60 years to find the existence of an insurrection within the meaning of an insurance policy, the insurrection has occurred against, not by, the established, effective, and de facto government, end quote. Pan Am World Airways, Incorporated v. Aetna Casualty and Surety Company, 1974, quote, the district court held that the word insurrection means 1. A violent uprising by a group or movement, 2. Acting for the specific purpose of overthrowing the constituted government and seizing its powers, end quote. Accord, e.g. Home Insurance Company of New York v. Davila, 1954, noting that if Puerto Rican extremists had a maximum objective to overthrow of the insular government on the island, that group's uprising would constitute insurrection. Hartford Fire Insurance Company v. Western Union Company, 2022. A Russian-backed separatist group's attack on a plane in service of overthrowing the current government in eastern Ukraine was an insurrectionary act. Eunice Brothers and Company, Incorporated v. Cigna Worldwide Insurance Company, 1996, applying Davila in finding that where individuals outside of the Liberian government, quote, led their respective armies in a violent uprising, end quote, against the Liberian government, end quote, damage to properties fell within an insurance contract's insurrection clause. The office did not find any case in which a criminal defendant was charged with insurrection for acting within the government to maintain power, as opposed to overthrowing it or thwarting it from the outside. Applying Section 2383 in this way would have been a first, which further weighed against charging it, given the other available charges, even if there were reasonable arguments that it might apply. As to the second element under Section 2383, there does not appear to have ever been a prosecution under the statute for inciting, assisting, or giving aid or comfort to rebellion or insurrection. The few relevant cases that exist appear to be based on a defendant directly engaging in rebellion or insurrection, but the office's proof did not include evidence that Mr. Trump directly engaged in insurrection himself. Thus, however strong the proof that he incited or gave aid and comfort to those who attacked the Capitol, application of those theories of liability would also have been a first. See Alexander Cesis, Incitement to Insurrection and the First Amendment, 2022. Quote, the likelihood of conviction under the Federal Incitement to Insurrection Statute, 18 U.S.C. Section 2383, is fraught with uncertainty because no federal court has interpreted it." End quote. The office determined that there were reasonable arguments to be made that Mr. Trump's ellipse speech incited the violence at the Capitol on January 6th and could satisfy the Supreme Court standard for incitement under Brandenburg v. Ohio, 1969, holding that the First Amendment does not protect advocacy, quote, "directed or inciting or producing imminent lawless action and likely to incite or produce such action," end quote, particularly when the speech is viewed in the context of Mr. Trump's lengthy and deceitful voter fraud narrative that came before it. For example, the evidence established that the violence was foreseeable to Mr. Trump, that he caused it, that it was beneficial to his plan to interfere with the certification, and that when it occurred he made a conscious choice not to stop it and instead to leverage it for more delay. But the office did not develop direct evidence, such as an explicit admission or communication with co-conspirators, of Mr. Trump's subjective intent to cause the full scope of the violence that occurred on January 6th. Therefore, in light of the other powerful charges available, and because the office recognized that the Brandenburg standard is a rigorous one, see e.g. NAACP v. Claiborne Hardware Company, 1982, speech delivered in passionate atmosphere that referenced, quote, "possibility that necks would be broken," end quote, and violators of boycott would be, quote, "disciplined," did not satisfy Brandenburg standard. Brandenburg, reversing conviction where Ku Klux Klan leader threatened revengeance for suppression of the white race. It concluded that pursuing an incitement to insurrection charge was unnecessary. By comparison, the statutes that the office did charge had been interpreted and analyzed in various contexts over many years. The office had a solid basis for using sections 371, 1512, and 241 to address the conduct presented in this case, and it concluded that introducing relatively untested legal theories surrounding section 2383 would create unwarranted litigation risk. Importantly, the charges the office brought fully addressed Mr. Trump's criminal conduct, and pursuing a charge under Section 2383 would not have added to or otherwise strengthened the office's evidentiary presentation at trial. For all of these reasons, the office elected not to pursue charges under Section 2383. F. Co-conspirator liability. As described in the factual recitation above, Mr. Trump was charged with participating in crimes with at least 6 co-conspirators, and the office's investigation uncovered evidence that some individuals shared criminal culpability with Mr. Trump. Following the original indictment on August 1, 2023, the office continued to investigate whether any other participant in the conspiracies should be charged with crimes. In addition, the office referred to a United States Attorney's Office for further investigation evidence that an investigative subject may have committed unrelated crimes. Before the department concluded that this case must be dismissed, the office had made a preliminary determination that the admissible evidence could justify seeking charges against certain co-conspirators. The office had also begun to evaluate how to proceed, including whether any potential charged case should be joined with Mr. Trump's or brought separately. Because the office reached no final conclusions and did not seek indictments against anyone other than Mr. Trump, the head of the criminal conspiracies and their intended beneficiary, this report does not elaborate further on the investigation and preliminary assessment of uncharged individuals. This report should not be read to allege that any particular person other than Mr. Trump committed a crime, nor should it be read to exonerate any particular person. This concludes this episode of The Docket. I hope you enjoyed this reading. For updates on The Docket, please visit docketpod.com or find us on Threads as DocketPod. If you found this useful or interesting, please consider subscribing to The Docket and supporting my Patreon at patreon.com/docketpod. Thank you.